Hi there, folks. This is Sam Price, and welcome to another episode of Probate Notes. I have a great guest on today that many of you might be already familiar with. I have Josh Yager, managing partner at Anodos Law. Hi there, Josh. How you doing today?
I'm good, Sam. Good to be
Good.
here.
Thanks for being on the show. First thing I want to do is just kind of get a little bit about your background. Why don't you tell us a little bit about you?
Well, when I was young, I wanted to be Gordon Gekko. And so I
Nice.
went,
Greed is good.
greed is good. And so I went into the financial services industry. My dream was to be a financial planner, money manager. Did that for 15 years. And during that process, I realized my job was just convincing people that our products and services were better than our competition and that they should fire their current advisor and hire us. And so I kind of had a crisis of career. And my employer, after you got to a certain level, said, yeah, we'll pay for continuing ed, whatever you want to do. Most of my colleagues did CFAs or MBAs, and I did law school at night. So I grounded out and got my bar card in 2005 when I was 35, and I had worked doing financial services for 15 years. And came out and started a legal practice with a buddy, kind of a help old rich guys in Montecito, Santa Barbara, where I live, with all sorts of project management. So kind of family office, but without money management. And got exposed to a whole lot of highfalutin estate planning attorneys in LA and San Francisco. And my buddies, who are school teachers and pastors and bricklayers, would come to me and say, hey, Josh, you're a trust and estates guy. Can you help me with my estate plan? And I would say no. And then I realized, dude, these people need help because they're either going on Zoom or on, what is it? The one that you do by yourself? Legal Zoom.
Yeah.
They're going on Legal Zoom and they set up a fine document, but they never fund it. Or they're paying 20 grand for a boilerplate estate plan where they're a non-taxable family. And a couple of years ago, my partner and I said, hey, let's go down market and serve clients that are like our parents and ourselves that need estate planning, but we need to reimagine how the service is delivered with a particular emphasis on the estate settlement piece, which is kind of the forgotten discipline within the estate planning practice because there's so much demand for document drafting. Our colleagues are too busy with document drafting that there's not a lot of time to engage with the frustrating process of settling. So probably half of our practice is settlement. That's what we specialize in. That's the hill I want to die on. We do drafting documents if the neighbor needs an estate plan, but mostly settlements are a thing.
You talk about a coming gray wave. Do you want to describe that to us?
Yeah, it freaks me out, and it's a killer opportunity for those of us in the trust and estates practice. We got 10 million baby boomers in California. All of them are going to be dead in the next 30 years. They currently control about $20 trillion of assets. And there's only 5,000 trust and estates attorneys. So the math doesn't add up. And it's worse. A third of the best trust and estates attorneys are themselves baby boomers. A third of the best judges are baby boomers. A third of the best paralegals. So we're not replacing, there's a brain drain. With the best and brightest are leaving practice, and our kids don't want to come in and be trust and estates attorneys. They want to be influencers or go work for Google. And it's like, dude, if you want a growth industry, we are sitting on it right now.
Right. What can people expect over the next 10, 20, 30 years?
That the current long delays in attorneys' schedules is going to get worse, and that the fees to engage a trust and estate attorney is going to go up. It's just a supply demand math. Like how drafting docs, what is 5 years ago? A typical document set would be $5,000. If you look in LA and San Francisco, Sacramento, I think it's like 7 or 8 right now.
Mm-hmm.
And it's gonna, that geometric progression is gonna get worse. And it's gonna get, my thesis is, and the most time consuming, most expensive piece of the entire estate continuum is the settlement. And 2/3 of our colleagues don't do settlements because they're busy with drafting docs and doing planning.
Can you describe when someone dies, what are the three different types of assets that someone has?
Well, you've got the non-probate assets. That's the easiest one for everyone to understand. It's a piece of paper that says there's a beneficiary. So that Northwest Mutual has dad named as the owner of the annuity and mom as the beneficiary of the annuity, and the trust is the contingent beneficiary. Like everything happens by operation of law. You show a death certificate and you fill out some paperwork, that asset transfers irrespective of what the trust says to whomever is written on that document, to some families' detriment because we forgot to take the prior spouse off of the IRA or the life insurance policy.
So
Or
that's
we had mom first. The more common theme is we have mom first on dad's IRA, mom dies. There isn't any contingent beneficiary on a non-probate asset, an asset that's designed to pass in 30 days. Get your death certificate, fill out the paperwork, you get the life insurance policy or the annuity or the IRA. That's the non-probate asset that is supposed to transfer. But if that
non
paperwork isn't square, it doesn't. We got a
not
probate problem.
for non-probate assets, a will doesn't control it and a trust doesn't control it.
Correct.
And so what mistakenly some clients think is that, well, look, I put this in this paperwork in my will or my trust, and I think that that non-probate asset should be according to the terms of the
Yeah.
document. Okay. That's one type of property. What are the other types of property?
The other type of property is a trust asset. We went through the exercise of writing down, expressing what we wanted to have happen to our stuff as a trustee of our stuff. And then we retitled our stuff, our house, or our stock portfolio, or our bank account, or our safety deposit box. We took an active step of changing the name of the thing so that the words of the trust apply. The trust is a bucket or a box, and the trust language are your instructions that go into the box. And any assets that are in the box, that language tells what's to happen with it. And though the language may be prosaic, though clients may have a hard time reading a 50-page trust document, trust me, there are instructions in there and they're clear, and a judge will know how to interpret them and what's supposed to happen for the assets that have been retitled as a trust asset. And then the last are probate assets, assets that are neither non-probate assets with a beneficiary or trust assets that have been retitled. Probate asset means there isn't any title, and a judge has got to sort out the bodies.
Have you ever run across a situation where a, a the settler wants the house to be kept within the family, so someone always have a place to live, and they want the house never to be sold? Have you ever come across a situation like that?
I've seen that more with the vacation house. I've seen it with the vacation house, and it actually, for many families, is a millstone around their neck that they don't have enough money to fund the thing, or one of the branches of the family doesn't continue to go there. I see it sometimes with the life estate. I want the third wife to be able to live in the house for the rest of her life. So I see it sometimes.
Yeah. Yeah. So next thing up, so the best thing to do is to decide ahead of time, write that down into the trust and an amendment or into their intentions of what should be done.
Yeah.
Okay.
Yeah. And here's a subset of that, the personal property piece. There are so many fights in families that are over silverware and cars that it's so easy for mom and dad to solve that ahead of time. Who gets grandma's ring? Like the consternation that could be solved by saying, we're going to have an issue here. Dad's got he's got a 64 Porsche that's in mint condition, and he's got 3 boys. Like, we're going to have a problem. You don't have to be a rocket scientist to know that there's going to be an issue. So dad, tell us what to do. Don't leave that to the oldest brother to decide. So the personal property piece is helpful. If we get some guidance, we just ask the family, hey, are there any assets that are really important to some kids and not to other kids, or all the kids want the same thing? And isn't it kind of predictable it's going to be a problem? And do you have any guidance for us on these particular personal property items, particularly the ones that are hard to divide? The gun collection you can divide, the Porsche you can't divide.